Good afternoon, and thanks for joining Washington, D.C.-based Jennifer Schaus & Associates in our DFARS cited in 2020 complimentary webinar series. As you know, the FAR Federal Acquisition Regulations is the rulebook that the federal government must follow in making purchases. Our webinar series pulls from contracting experts to explain each part of the FAR. It is complimentary and recorded. We'll post all the recordings on our website and YouTube channel where we have over 300 government contracting webinars available for download. A special thanks to our webinar partner in the series, the National Veteran Small Business Coalition Education Foundation. Please visit their website to learn more about the organization. We would also like to thank our friends at Open the FAR for their sponsorship. If your organization is interested in sponsoring the series or one part, please contact hello@jenniferschaus.com. And now a little bit about us. We work with primarily large businesses to help them navigate the federal marketplace. We work with both product and service companies as well as software firms. Our clients span the globe and include publicly traded organizations in a variety of sectors. We provide market analysis reports, contract administration, contract vehicle assistance, and more. All of our services can also be built into a training course for your team. Learn more about us on our website. And now we would like to let you know about some ways to reach government and government contractors through us. We offer advertising and sponsorship opportunities through our weekly newsletter and also in our webinar series. For pricing or to place an order, please email us at hello@jenniferschaus.com. Also, please join us on Tuesday, June 23rd for our virtual Hot Topics in GovCon virtual conference. This is a remote conference. Please use the link on the screen to register. You can also visit the events section on our website to register. During this conference, we will take your live questions, and the PowerPoint and webinar will only be available to those who register for the conference. We really hope to see you there. Now let's move on to learn a bit about today's speaker, Janetta Brewer. You can find her contact information on the screen here. Today we are covering FAR Part 24 with Janetta. Thank you so much for joining us today. We're really thankful for your participation in the series. The floor is now yours, and please let me know when you're ready for your next slide.
Thank you so much for allowing me to be here today. You can go to the next slide, please. So today we will be talking about FAR Part 24, and as many of you, I'm sure, are aware, privacy is increasingly becoming more and more of a hot topic in the government space, especially with all of the data breaches and the cybersecurity attacks that relate to information being released to unauthorized parties. So today we'll have an opportunity to talk about how the federal government goes about protecting some of that information, particularly as it relates to information that government contractors have access to through contracts that require them to put into place systems of records on individuals. So FAR Part 24 prescribes the policies and procedures that apply to requirements of the Privacy Act of 1974 and OMB Circular number A130. So many of you are probably aware that, Congress enacts laws, and through those laws, sometimes there are requirements that Congress wants to pass on to government contractors. So the way that those requirements that are in the various laws and statutes that are executed by Congress, the way that they come and flow to the government contractor is through the Federal Acquisition Regulations, and through the FAR, there are clauses that are placed in the FAR that impose those requirements on government contractors. So the Privacy Act requirements contained in the FAR, or that come through the Privacy Act of 1974, are implemented through FAR Part 24. Next slide, please. This slide provides an overview of how FAR Part 24 is framed. So the first part of FAR Part 24 deals with the Privacy Act, procedures of the Privacy Act, and how those procedures are impacted or imposed upon government contractors. And then the second part of FAR Part 24 touches on the Freedom of Information Act. So you have two, various parts. You have one where there is this need to protect information and to keep it private. But then you also have a separate part dealing with the freedom of information, which relates to how do we make information that's collected by the government, because the government, is in place of the people and for the people and by the people. So how do we ensure that the information government is obtaining, that certain information is made available to private citizens when they have a desire to know. So you have two potentially contentious parts of the at war, so to speak, in this part of the FAR. Next slide, please. So we'll start by talking about the Privacy Act in general. So before we get to the actual FAR requirements and what's contained therein, I'd like to start by just providing a big picture overview of the Privacy Act of 1974. So within the Privacy Act, it states that when an agency provides a contract for the operation by or on behalf of the agency of a system of records to accomplish that agency function, the agency shall cause the requirements of this section to be applied to such systems. So Privacy Act contains lots of different requirements as relates to information and the protection and privacy of that information. When a government agency puts into place a system of records, those same requirements that are contained in the Privacy Act, the agency has to ensure that those requirements related to privacy and the protection of information applies to the system of records and obviously all of the information that's contained in that system of record. Additionally, for purposes of subsection I of this section of the Privacy Act, the requirements also apply to contractors and the employee of those contractors. So for purposes of the Privacy Act, contractors and their employees shall be considered employees for purposes of ensuring that the protections that apply to the system of records apply also to contractors who are operating those systems of records on behalf of the U.S. government. Next slide, please. So this part kind of provides what the requirements are. So any officer or employee of an agency has a responsibility of ensuring that information that's contained within the agency record is prevented from being disclosed to unauthorized sources. So it provides, that general restriction, but also states that to the extent that the information is knowingly and willfully disclosed, there are criminal penalties associated with it. And again, the reason this matters to those of us who are listening on the call is because for purposes of the Privacy Act, contractors and employees of contractors are considered the agency for purposes of the Privacy Act. So those same criminal penalties that apply to an officer or an employee of an agency would also flow down and apply to contractors and their employees for purposes of this act. Also, I also want to make note, not only does a contractor open itself up to legal penalties, which is stated here in the Privacy Act requirements here, it also opens itself up to other negative consequences. So to the extent that a contractor or a contractor's employee discloses or violates provisions of the Privacy Act in performance of a contract, there are also other negative consequences like that could lead to being in default of the contract. So you could be terminated for cause or default. It could impact future awards, and if egregious enough, it could also cause the agency to seek debarment or suspension against the contractor. So it's important for those listening to know and understand that though the Privacy Act and the requirements that are going to be contained in the FAR and the clause only kind of speaks to those criminal penalties, there are also lots of other negative consequences that are associated with not complying with these requirements. So it's important that the government contractors have sufficient controls in place to ensure that not only the contractor, but also the employees that are employed by the contractor, sufficient controls are in place to ensure that they're not breaching these requirements. Next slide, please. So we've spoken about the general requirements of the Privacy Act, and this provides some color on why the Privacy Act was implemented. So back in 1974, Congress had a desire to balance the need for the government maintaining information about individuals. So if you think about information that's collected through the Social Security Administration for knowing and understanding when folks are eligible for benefits, or you think about from IRS standpoint and the information that's collected about individuals as it relates to taxes that are paid and tax payments that are made. So across the federal government, there's a need for the government to collect information about individuals in order for it to be able to execute their various missions. But that need for the government to have information needs to be balanced with or against the rights of individuals to be protected against unwarranted invasions of their privacy, because as individuals in our democratic society, we have a constitutional right to privacy. So the government has a need to balance these two juxtaposed positions. Additionally, Congress was concerned about curbing the illegal surveillance and investigation of individuals by federal agencies at the time that came out during the Watergate scandal. And also computers were coming into wider use. So instead of the paper system, which, made it easier to control information because people would need to have access into a government agency to be able to collect data. Now you got computers popping up all over the place. And so the ability to send information out through electronic means and for folks to reach into government systems and have access to data increased as well through the usage of computers. So the government also had an interest in helping against those potential abuses. Next slide, please. So these are the definitions that are provided in FAR Part 24. So for awareness, in each of the various parts of the FAR, you might find different definitions that are contained. And for purposes of the FAR, it's saying that these definitions only apply to this part of the FAR. So as used in FAR Part 24, these terms have these specific meanings. So there may be instances where you see in FAR Part 2 a different definition being provided, but for purposes of FAR Part 24, these are the definitions that stand. So agency has a definition which includes all of the executive departments, the military departments, also including independent regulatory agencies like SEC, for instance, provides a definition for an individual, meaning a citizen or a lawfully admitted alien, provides personally identifiable information, information that can be used to distinguish or trace a person's identity, especially if it's combined with other information where you can link the information together and figure out who that particular person is. So again, the main purpose of FAR Part 24 is protecting that type of information. A record, as used in this part, means any types of items, including education, financial transactions, medical history, criminal or employment type information. And the system of record, which FAR Part 24 is intending to protect information that's contained in the system of records on individuals, applies to system of record of individuals means any system or records that has information that can be retrieved by either the name of the individual or some other identifying symbol, whether it's a fingerprint or it's a unique identifiable number or some other thing that's provided that replaces the Social Security number. Next slide, please. FAR Part 24-102 contains the general requirements contained in FAR Part 24. So essentially, you'll hear here a lot of information that's repeated from what we talked about before that's contained in the Privacy Act itself. So in paragraph A, talks about the general requirements that link back to the Privacy Act of 1974, essentially saying if an agency is contracting for design, development, or operation of this system of records, that agency has to ensure that the requirements of the act are applied to the contractors and to the employees working on the contract. Paragraph B talks about what we've seen before, that the agency or its employees may be criminally liable, and that liability also applies to contractors and their employees. So for purposes of this part of the FAR, contractors and their employees are considered employees of the agency for purposes of applying criminal liability in instances of breaches of this provision. Paragraph C makes the requirement, applies these requirements through the clauses contained in the contract. So if the contract specifically provides for this design, development, or operation of a system of records, the agency has to ensure that those requirements apply to the contractor, and that happens through the contract clauses that we have in place. And then paragraph 4 says that to the extent that agencies do not follow these provisions, they may be civilly liable to individuals who are injured as a consequence of any subsequent failure to maintain records in conformance with the Act. So that's essentially saying that to the extent that, say for instance, information that's collected by IRS on an individual is released, and that information, contains bank account type information, and then that individual, because that information was released, and another person had access to it and used it in ways that financially harmed the individual whose records were breached, the government can be held liable for the injuries, the financial injuries that that person was subject to. And then that liability could also be applied to contractors and their employees. Next slide, please. So again, this part of the FAR is really concerned about the system of records on individuals and protecting data and information that's contained within those system of records on individuals. So what is a system of record on an individual? It's a group of data that contains a unique personal identifier, could be a name, DOB, Social Security number. It could contain other type of information like home address, performance, rating, blood type, things like that, depending on the agency collecting the information. And data about the subject individual is retrieved by their unique personal identifier. Next slide, please. So how does the government, so we kind of walked through the requirements that the agency has as far as ensuring that information that's contained within these system of records on individuals is protected and made private. So how does the agency go about ensuring that the requirements that it has to follow are made available to government contractors to ensure that the government contractors are following those requirements as well? So FAR Part 24.103 provides the procedures that the government follows to, one, know and understand whether or not they have a contract or a request for proposal that will contain system of record information, and then two, provide some method for how they provide information to government contractors to ensure that those requirements that are imposed on the agencies flow down to the government contractor. So in paragraph A, there's a determination that the contracting officer has to make in reviewing requirements to ensure or to determine whether or not the requirements involve the design, development, or operation of a system of records. So the contracting officer reviews the requirements that are developed by the program manager or the program management office. And in reviewing those requirements, the contracting officer has to make a determination whether or not any future contract will require the design, development, or operation of a system of record on individuals. If the contracting officer's determination is yes, it will require or involve the design, development, or operation of a system of record. Then the contracting officer has the responsibility to, one, ensure that the contract work statement specifically identifies both the system of record on individuals and the design, development, or operational work to be performed. And the contracting officer has responsibility to make available, in accordance with the agency rules, agency procedures, any rules and regulation that each individual agency has in implementing the act. So as government contractors, if we review a RFP or solicitation that's been issued and we notice language surrounding a system of record on individuals, to the extent that we see and notice that these have not been made available, meaning the government has not specifically identified what that system of records is, and the statement of work doesn't clearly identify what design, development, or operation related tasks are associated therein that support it, then we would be required to say to the government, hey, government, we need further clarification around this, because again, those requirements that are on the agency flow to government contractors. So it's important that we ensure that we understand what those requirements are and that they're clearly spelled out within the statement of work in the contract. So as noted here, that contracting officer has this requirement to make a determination. Generally speaking, whenever in the FAR there is a requirement for a determination to be made by a contracting officer, you can usually assume rightly that the process for how that determination is made will be contained within the agency's internal procedures. And each agency is likely to have developed their own process for how that determination is made. So we'll go to the next slide, and on the next slide, it'll provide an example of a process that's been put in place by the VA, the U.S. Department of Veterans Affairs. So in VA Handbook 6508-1, they have procedures for privacy threshold analysis and privacy impact assessment. So their way of helping the contracting officer to make the determination that we talked about before, they have a privacy threshold analysis. And that is a privacy, compliance, and risk management tool that is used within the VA on any new requirements in order to assess whether or not the information that's being collected and maintained, to determine whether or not PII information, personally identifiable information, or personal health information will be collected and maintained by an IT system, rulemaking program, and/or project. And so the person who's developing the requirements, usually the program manager, will have this requirement to, as they're building their requirement, completing this privacy threshold analysis that will lead and help make the determination whether or not PII is going to be collected. To the extent that PII is collected, within the VA, they have another step, which is the privacy impact assessment, which talks through designing to identify what the privacy and security related risks are associated with the information that's being collected. So again, I'm just providing here an example of how one specific agency, the process they put in place to help contracting officers with the determinations around this. And typically all of the agencies will have some version of a process that they're leveraging to ensure that the requirements that they're putting out and the contracts that they have in place to assist with ensuring and determining whether or not information is being collected, and to the extent that it is, what's the risk of that information to the extent that it's disclosed, and that will help the agency kind of determine what type of controls and protective measures they need to put in place to protect that information. Next slide, please. So here we'll talk, provide the clauses. So again, within the FAR, you have all of the requirements that are kind of levied against contractors, but it really doesn't apply to the contractor until it makes its place into a contract. So these are the clauses that have been developed to ensure that contractors are aware of Privacy Act requirements, and also to ensure that they're aware of all of the measures and controls around protecting information. Next slide, please. So the first clause is the Privacy Act notification. So this essentially is just a notification to the contractor saying, hey, guess what? You're going to be required to design, develop, or operate a system of records on individuals that's subject to the Privacy Act of 1974. And also, guess what? There may be imposition of criminal penalties. So as a government contractor, you should always know and understand what contract clauses are contained in your contracts. To the extent that you see this clause, it goes back to the requirements that we mentioned earlier. So there's certain information that the government contracting officer has to make available through the statement of work if the contract involves a system of record on individuals. So to the extent that you see this requirement contained in your contract, ensure that the statement of work contains that required information related to clearly identifying the system of records that is involved, and also the design, development, or operation work that is to be performed. Also make sure that it's clear within the RFP any agency procedures, rules, and regulations that the agency has in implementing the Privacy Act, because you're not just required to follow the FAR, you're also required to follow any agency's rules as well. So we have a responsibility. If we see this notification in our contract, make sure the government's done its part in being upfront with all of the information that they have a requirement to provide. Next slide, please. And so the next one provides the specific or imposes the specific requirements on the contractor. So in paragraph A, it spells out some of the requirements that we've already talked about contained in the FAR. So it's essentially the contractor is agreeing through signing the contract that the contractor will comply with the Privacy Act requirements and with the agency rules and regulations. It includes, the contractor agrees to include the Privacy Act notification contained in this contract in every solicitation and resulting subcontract, and also in every subcontract award that's made without a solicitation. So this is where the slowdown requirements associated with this are provided for. And then in paragraph 3, it states to include this clause, the clause itself, in all subcontracts awarded under this contract. So you have two flow down provisions provided here. You have the flow down provision of the Privacy Act notification itself, and then the flow down provision of this Privacy Act clause that have to be flowed down, and those are provided in paragraphs A, 2, and 3. In paragraph B, it provides the notification that in the event that there is a violation of the Privacy Act, a civil action may be brought against the agency. And oh, by the way, contractor is considered to be an employee of the agency for purposes of this clause. So essentially providing notification to the contractor of all of the things that we've discussed before. Next slide, please. Next slide, please. Oh, I'm sorry, can you go back? I think you. Thank you. So now we know and understand there's this Privacy Act of 1974. There are a lot of requirements that the agency employees, and also contractors are required to abide by. And government contractor, and you've been notified that you have a requirement in this area. So how does a contractor know and understand what all of those requirements are in a meaningful way, and how do you understand how to go about not being in non-compliance with this area. So the government has in FAR Part 24.301, there's a requirement that contractors are trained. So contractors have a requirement or a responsibility to ensure that initial privacy training and annual privacy training thereafter is completed by all contractor employees. And any contractor employee who has access to a system of records, who creates, collects, uses, processes, stores, maintains, disseminates, all of that that's contained in A2, or who designs, develops, maintains, or operates a system of records. So anybody who has access or could potentially have access in the day-to-day responsibilities has a requirement to complete privacy training. Next slide, please. Contractors have a responsibility of ensuring that the individuals that are trained, the training has to include or address these specific requirements. So it has to address the key elements necessary for ensuring that the safeguarding of personally identifiable information for a system of records. At a minimum, the privacy training has to cover the provisions of the Privacy Act of 1974 that we've discussed, the appropriate handling and safeguarding of personally identifiable information. So generally speaking, you know, how is that information safeguarded from a physical standpoint? Like if you have physical documents, how do you safeguard that information? Do you designate a drawer, for instance, and require that it be locked? From a technical standpoint, how are you safeguarding information? And also from an administrative standpoint. The training shall also cover the authorized and official use of a system of records, restriction on the use of unauthorized equipment to create, collect, use, or process personally identifiable information. And in paragraph 5, it talks about the prohibition against the authorized use of a system of records or unauthorized disclosure, access, handling, or use of personally identifiable information, and then what procedures should be followed in the event you suspect a breach or a breach is confirmed. One of the things to make note of here, I actually had a client where the government was coming in to do incurred cost audits, and in performing their incurred cost audits, they wanted to know, well, where is this information contained? And the information for that specific contract, the contractor supervisor had found that the person was storing it on their personal computer. So for purposes of the incurred cost audit, obviously there was an exposure of, you know, not having adequate controls in place. But what it also did was open up a situation where the contractor is now demonstrating a breach or non-compliance in other requirements that they have within the FAR. So I'm providing that as an example of different ways that it could be determined or that you could be notified that an employee is breaching this provision that's contained within your contract. And to the extent that you're aware of that, there's a requirement to notify the government. Next slide, please. So the contractor can either provide its own training or use the agency training. The clause will determine whether or not which method should be applied. So in the clause that's contained in the contract, it will either say, okay, you can develop your own training or use another agency's training, or, you know, as DOD, we have our own training that every contractor employee is required to complete. Contract is also required to maintain and provide documentation of completion. So privacy training is a contract requirement that must be met if the clause is in the contract. And that means it's something that is subject to audit. So everybody's encouraged to always keep records. And And then no contractor employee shall be permitted to have access or do any of these things that are provided in paragraph E unless the employee has completed the privacy training. So contract performance can be delayed or impacted by not successfully meeting these requirements associated with the privacy training. Next slide, please. And this just provides that the requirements of the privacy training have to be flowed down to subcontractors, obviously, because if a contractor has a requirement that is flowed down to subcontractors related to Privacy Act requirements, then it makes sense that there would also be a training requirement that flows down to them as well to ensure that they know and understand the requirements contained therein. Next slide, please. Here are a list of the tips that you can use to avoid breaches of personal identifiable information. One, take protection of it seriously. Respect the privacy of others. Alert a management official if you see or notice that PII is left unattended. So government contractors can talk to their employees and encourage their employees. If you see another employee of the company who's left something unattended, obviously that's a breach that could expose the entire company to unintended and negative consequences. So everybody has a responsibility to ensure that the whole is compliant. Make sure you know and understand the Privacy Act requirements. Ensure that information is properly marked and encrypted, and do not email PII of others to a personal email account or store it on a personal email folder, a personal computer. So work accounts and work documents should only be maintained on a work computer. None of that information that's on a work account or computer should migrate to any personal accounts or computers. Next slide, please. So next we'll be transitioning into conversation around the Freedom of Information Act. So we talked about the huge need to protect information that the government is collecting. Now we're transitioning to the public's need for accessing information that the government is collecting. So here's a little bit of background information on the Freedom of Information Act, also called FOIA. The basic function of the Freedom of Information Act is to ensure that citizens are informed. Again, we're a democratic society. Folks have a right to know, have a right to information. That's how we, are informed and make decisions going forward. So since 1967, FOIA has existed to provide the public with a right to access records from any federal agencies. Within FOIA, there's a requirement levied against the agencies that require them to disclose any information requested under FOIA unless it falls under one of 9 exemptions. So these 9 categories of information or exemptions are provided to ensure that information that would be harmful to the government or to some private interest aren't disclosed. Next slide, please. So on this next slide, it provides what those exemptions are. I will not go through all of them in detail. For purposes of this audience, I think the one that you would be most interested in is the one at the FOIA exemption at number 4. So trade secrets, commercial or financial information that is obtained from outside of the government and that is privileged or confidential is exempt from FOIA, a FOIA request. So obviously, a lot of the information that comes through into the government in the form of proposals, it's proprietary, it's confidential. Businesses do not want that information disclosed or made available to other companies for competitive reasons. And so many would-be government contractors would not feel comfortable submitting proposals or much of the information requested by the government if that information could easily be disseminated. So exemption 4 is the exemption that protects government contractors and that we usually rely on to ensure that information contained in our proposals is protected. Next slide, please. So in FAR Subpart 24.2 contains general requirements of the Freedom of Information Act, provides that information is made. It should be made available to the public, either by publication in the Federal Register, providing an opportunity to read and copy the records at a convenient location, or upon request by providing a copy of a reasonably described record. Next slide, please. So previous slide essentially said, generally speaking, information should be made available to the public. However, government always has an exception. So this is where the exceptions are contained. A proposal in the possession of or control of the government that is submitted in response to a competitive solicitation shall not be made available to any person under the Freedom of Information Act, unless that proposal or any part of the proposal is set forth or incorporated by reference in a contract. So advice to government contractors who are submitting proposals: when you receive a copy of the award document from the government, one of the things that you can talk to them about in advance is what information is confidential that should not be either set forth or incorporated by reference in that contract. It also provides that agencies shall not disclose information obtained pursuant to 15.403-3. And in that section, it really is talking about requiring data other than certified cost of pricing data. So to the extent that there has been adequate competition, usually you don't have to provide additional data as a government contractor to help the contracting officer make the price reasonableness determination. But there are sometimes circumstances where the government contracting officer decides that additional data is necessary. To the extent that a government contractor provides that data to the government, you have this provision of the FAR to rely upon that says that that information is exempt from disclosure. Next slide, please. So in this last slide, just talk through the policy requirements that are contained within FOIA and how agencies should comply with those. So within the Freedom of Information Act states that it provides how agencies shall make their records generally available to the to the public when the public requests. It also imposes strict time standards for agency responses and exempts certain records from public disclosure. Each agency's implementation of how they abide by or implement these requirements are contained within their respective title of the Code of Federal Regulations and also referenced in Subpart 24.2 of their implementing regulations. So I've been talking about how, from a FOIA standpoint, there's a need as a government contractor to protect the information, the proprietary and financial information that we're disseminating to the government. But there's also a right that we have as a government contractor to, when we have or desire information about certain requirements and solicitations and awards, we have not an obligation, but we have a right to certain information and data as well as it relates to that award. So, and the government has certain timelines that they have to abide by in providing us the information or responding to us, whether it can be disclosed or not. And if in paragraph B, it talks about the contracting officer may receive requests for records that may be exempted in that exemption that we listed, that we showed before. And that type of information that could be restricted from disclosure is classified information, trade secrets, or other confidential, commercial, or financial information. Government agency KOs, contracting officer, are advised to seek counsel of their FOIA. So usually agencies have a FOIA officer. Because making these determinations about what can be released under the Freedom of Information Act usually involves a lot of complex issues requiring a lot of in-depth knowledge. court rulings and policy guidance, they're encouraged to really reach out to their FOIA officers within the agency. Additionally, I'd also advise on the government contractor side of the house, because FOIA is something that involves usually lots of complex issues, lots of layers of policies and agency regulations and guidance. Please seek counsel in this area as well. Next slide, please. So that concludes my presentation, and I'll turn it back over to you.
All right. Thank you so much, Senator, for a great presentation. Really appreciate your participation in the series. And to our audience members, we thank you again for participating with us. If you have any questions about this part of the FAR, please contact our speaker with the contact information you see on the screen. All right, and if you have any questions about federal contracting or need assistance with any of our services, please contact us directly. That concludes today's webinar.